going to go ahead and get started. All right, again, my name is Brandon Lewis, and I am an attorney advisor with the Office of Open Government, and this is FOIA Basic Training for Beginners. Today we're going to cover DC FOIA, which is in the DC Code in sections 2-531 through 2-540. There's also some additional sources that you may want to consult with regards to DC FOIA, and that includes the DC FOIA regulations, which are found at 1 DCMR, section 400, and the following sections. Independent agencies, DC FOIA regulations, advisory opinions of the Mayor's Office of Legal Counsel, and case law, including federal case law when the statutory provisions in DC FOIA is also in federal FOIA. Although this is not binding, it is instructive. Okay, and then here are just a few other sources. The Department of Justice guidance, OOG's FOIA advisory opinions, which are found on our website, individual agency program manuals, as well as the Office of Government Information Services. Okay, what are records under DC FOIA? Records that must be made available to the public without the need for a FOIA request include employee salary information, title, and employment dates, contracts, expenditures, budgets, manuals, policies, rules, opinions, orders, and the meeting minutes of open proceedings of public policies. And all of this information is contained at DC Official Code section 2-536. Public records include all books, papers, maps, photographs, cards, tapes, recordings, vote data, or other documentary materials, regardless of their physical form or characteristics, that are prepared, owned, used, in the possession of, or retained by a public body. Public records include information stored in an electronic format. Okay. And we're going to have some questions to kind of get you thinking about the material interspersed within the presentation. So here's our first scenario. I'll text you that information. Is the text a public record? Nick tells a fellow employee, I'm looking for my government-issued cell phone, and will text those government statistics the office has compiled to your government cell phone. Okay, and the question is, are text message public records? And then if you'll take a look, we've got a few potential options. No, text messages are not public records. B, no, if it's between government employees, it's private. C, it is up to each agency director to decide if they want agency text messages to be records. Or D, yes, they meet the definition of a public record. I'll give you guys a minute to put that in the chat if you want, with your guess. And if you put D, yes, they meet the definition of a public record, you are correct. In a March 16, 2022 advisory opinion, the Director of Open Government opined that a district government employee that conducts government business via a text or similar electronic method under the scope of employment creates a public record under DC FOIA. Okay. What if we store agency records on a personal server and email account at the agency director's home or off-site? The choices for this one are A, they are still agency records subject to FOIA. B, they are not maintained by the government and therefore not public records. C, they are not government records and lose their character once on the private server or stored off-site. Seeing a couple of folks put A, and that, of course, is the correct response. They are public records which are subject to FOIA. Okay. The term public record applies where the content is prepared or used by a public body. The means of the storage is immaterial. Government personnel cannot evade DC FOIA simply by preparing records on media that they happen to own. Okay, and here is a little bit of case law on this subject. Competitive Enterprise Institute v. the Office of Science and Technology, and the holding of this case, where an agency refused to provide requested records on the basis that the agency had maintained them on a private email account in his name at a site other than the government email site which the agency had searched, the requester's FOIA compliance action was erroneously dismissed because an agency could not shield its records under FOIA by the expedient of storing them in a private email account controlled by the agency head. If the agency head controlled what would be otherwise an agency record, then it was still an agency record and still must be searched or produced. Okay? It was not apparent that the domain where the email account was maintained controlled the emails therein, controlled the emails therein to the exclusion of the user, and the agency's claim was inconsistent with the purpose of FOIA, which was to serve the citizen's right to be informed about their government. So the takeaway from that is, if they are government records, housing them somewhere else, whether on a different email server or a different email address, does not magically make them not government records. Okay. Any person has a right to inspect and at his or her discretion to copy any public record. Any public record of any public body except as expressly provided by the FOIA exemptions. Okay, so who is any person that may submit a DC FOIA request? Does it refer to any District of Columbia resident? B, any natural person, or C, a person, natural or corporate, regardless of their residency or location? This one might be a little bit trickier than the last one, but I see some folks have entered in C, and that is the correct response. So while in Virginia, for instance, you must be a resident to submit a FOIA request for Virginia's records, under DC FOIA, any person includes non-residents and corporate entities. So in the case of DC FOIA, any person actually means any person. Does any include anonymous requesters? Here's an example of a potential anonymous FOIA request. No way to tell who I am, haha, at gmail.com. Sent a FOIA request that says, Dear FOIA officer, I am requesting copies of all records you have that mention Ray's Boom Boom Room nightclub. I am willing to pay up to $100 for these records. The records may be sent to me or any correspondence regarding this request at my email address. No way to tell who I am. Ha ha ha. Thank you and have a wonderful day. And so if you received a FOIA request, what would you do amongst the following options? A, email the requester and ask for their name, telephone number, and mailing address. B, delete it from your inbox as trash. C, send it to your subordinate to handle if you are a supervisor, or to your supervisor if you are a subordinate, and request that they handle it. Or D, process the request with the email address you have. Okay. I saw a lot of folks responding with the correct answer, which is D. Under 1 DCMR 402.3, FOIA does not require that the requester identify him or herself. In relevant part, this provision states a request shall include a daytime telephone number, email address, or mailing address for the requester. The exceptions are when an individual requests records pertaining to himself or herself and therefore possesses the ability to waive his or her own privacy interests, or when the requester seeks a fee waiver based on affiliation with an educational, news media, or other entity. Moving on to another scenario, we work with private contractors. Do any records include private contractors' records? The options for this: A, DC FOIA doesn't reach these records. B, yes, if the contractors are performing a government function. C, DC FOIA doesn't address this issue. And D, yes, but only if the contractors don't mind sharing the record. And the correct response is B. A public body shall make available for inspection and copying any record produced or collected pursuant to a contract with a private contractor to perform a public function, and the public body with programmatic responsibility for the contractor shall be responsible for making such records available to the same extent as if the record were maintained by the public body. And also, sorry, I should have mentioned this earlier, but if you have any questions about anything as I'm going along, feel free to drop it in the chat. My colleagues are monitoring it, and either they will respond to your question or I will get to it at the conclusion of the presentation. Okay, responding to a FOIA request. For records other than body-worn camera recordings, an agency must respond within 15 business days. And this is codified at DC Official Code Section 2-532 C1. For body-worn camera recordings, an agency must respond within 25 business days. And that's at DC Official Code Section 2-532 C2A. In unusual circumstances, an agency may invoke an additional 10-day extension by written notice to the requester, setting forth the reasons for extension and expected date for the determination. And DC Official Code 2-532E provides that failure to timely respond to a FOIA request is deemed a denial of the request. Okay, so what qualify as unusual circumstances? We'll look at a scenario for this. Okay, the FOIA officer believes the request for the review of 20 emails, given other non-FOIA responsibilities and the FOIA assistant being on leave, to be unusual circumstances and invokes an extension. A, it sounds unusual and I think it's all right. B, DC FOIA states what are unusual circumstances. Or C, DC FOIA does not provide guidance on the issue. This is decided by the agency guidelines. And the answer to this is, of course, B. DC FOIA states what are unusual circumstances. And this is in DC Official Code, Section 2-532 D2. Unusual circumstances are defined as the need to search for, collect, or appropriately examine a voluminous amount of separate and distinct records that are demanded in a single request, the need for consultation, which shall be conducted with all practicable speed with another public body having a substantial interest in the determination of the request, or among two or more components of a public body having substantial subject matter interest therein, or for body-worn camera recordings, the inability to procure a vendor that is able to perform the redactions within the 25-day time period provided under subsection C2 of this section. Communication may result in cooperation. Note on communication and cooperation. This comes from a 2016 court decision. States in relevant part, FOIA requester and the district entity receiving a request are not or should not be in an inherently adversarial relationship. Litigation is authorized as an enforcement mechanism, but it is not meant to be the inevitable path. Each case has presented its own discrete issues, but the constant is an apparent inability or unwillingness by both parties to communicate effectively to achieve the objectives animating FOIA. Both parties seem to have forgotten what FOIA is all about. And this was from the Fraternal Order of Police versus the District of Columbia. And so, of course, the takeaway from that is that our goal should be to communicate and cooperate with FOIA requesters so that we can give them the information that they are entitled to under the law. Okay. I need it yesterday. Request to expedite processing of FOIA requests. You receive a DC FOIA request seeking expedited processing. The request states and demonstrates a compelling need as per 5 U.S.C. Section 552A6E 1 and 2, Federal FOIA's expedited review provision. You may A, ignore the request completely, B, process the request under normal FOIA timeframes and explain there is no expedited review under district law, or C, expedite the request and respond to the requester prior to the 15 calendar day period and any lawful extension. And the answer to this one is B. The correct response is to process the request under normal FOIA timeframes and explain that there is no expedited review under district law. While there is a provision to expedite federal FOIA requests, there is no such provision in DC FOIA. The agency website reads, please use the portal for submitting all FOIA requests. It's the quickest method to get a response. The FOIA portal may be the simplest and best means to submit and process FOIA requests, but may an agency require the public to submit through the portal? As you'll notice here, my graphic is a bit dated as the district has moved away from FOIA Express to GovQA rather. And however, the scenario remains the same. So based on the following choices, yes, A, yes, because FOIA's public policy is to minimize costs and time delays to persons requesting information. B, yes, because of the ease of use of the portal. And C, no, an agency may not restrict the method a requester uses to submit a FOIA request. I've seen a number of folks enter in C in the chat, and that is the correct answer. An agency may not restrict the method a requester uses to submit a FOIA request. 1 DCMR section 402.1 states, a request for a record of an agency may be made orally. 1 DCMR 402.3 says requests may be mailed, faxed, or emailed. Email, faxes, and mail requests must state FOIA request on the subject line or envelope. Then at the bottom for submissions to OAG, 1 DCMR section 1302.1, unless agreed to in advance and confirmed in writing by the Office's Freedom of Information Act officer or the Chief Deputy Attorney General in the absence of a designated Freedom of Information Act officer, a request for a record shall be made in writing. Again, that one was specific to submissions to OAG. Categories of exemptions. And these are contained at DC Official Code Section 2-534. It's an exemption for trade secrets. And these are commercial or financial information obtained from outside the government to the extent that disclosure would result in substantial harm to the competitive position of the person from whom the information was obtained. 2, personal privacy. Information of a personal nature where the public disclosure thereof would constitute a clearly unwarranted invasion of personal privacy. 2A, any body-worn camera recordings recorded by the Metropolitan Police Department, either inside a personal residence or related to an incident involving domestic violence, stalking, or sexual assault as defined by the DC Code. 3, investigatory records compiled for law enforcement purposes, including records of counsel investigations and investigations conducted by the Office of Police Complaints, but only to the extent that the productions of such records would interfere with enforcement proceedings, counsel investigations, or Office of Police Complaints ongoing investigations, and deprive a person of a right to a fair trial or an impartial adjudication, constitute an unwarranted invasion of privacy. Or disclose the identity of a confidential source, and in the case of a record compiled by a law enforcement authority in the course of a criminal investigation, or by an agency conducting a lawful national security intelligence investigation, or confidential information furnished only by the confidential source, and where it would disclose investigative techniques and procedures not generally known outside the government, or endanger the life or physical safety of law enforcement personnel. Okay, exemption 4, common law discovery privileges. This would be attorney work product, which applies to documents prepared by or for an attorney in anticipation of litigation, no matter the status or stage of the litigation. Attorney-client privilege protects confidential communications between the agency and the attorney. So the deliberative process, the method through which an agency creates policies, opinions, rules, and regulations. To qualify for this exemption, the record must be both pre-decisional and deliberative. Pre-decisional documents are those that are generated before the adoption of an agency policy. A document is deliberative if it is a part of the agency give and take of process by which the decision itself is made. Okay. And then the exemptions go on and include future examination test questions, info specifically exempted by other statutes, national security matters, antitrust investigations, etc. I'll let you read those. Okay. Then the exemptions continue on. Future evaluation, certain information of private vehicles for hire. So as you can see, there are a number of exemptions, reasons for exemptions that can be found in the DC code. Okay, next scenario, FOIA requester seems to want this, or maybe that. It's unclear to me. So I should A, contact the requester and seek clarity. B, put the request on hold until the requester inquires about the request. Or C, put the request on hold, immediately contact the requester and seek clarity. Inform the requester of the status and document attempts to reach the requester. Okay, and the correct answer is C. Put the request on hold, immediately contact the requester and seek clarity. Inform the requester of the status and document your attempts to reach the requester. And then a few bits of code from the DCMR on this subject. A request shall reasonably describe the desired records. Where possible, specific information regarding names, places, events, subjects, dates, files, titles, file designation, or other identifying information shall be supplied. Where the information supplied by the requester is not sufficient to permit the identification and location of the record by the agency without an unreasonable amount of effort, the requester shall be contacted and asked to supplement the request with the necessary information. Every reasonable effort shall be made by the agency to assist in the identification and location of requested records. If a requested record cannot be located from the information supplied, the requester shall be so notified. And when the Freedom of Information Officer, pursuant to Section 402.5, contacts the requester for additional information, then the request is deemed received when the Freedom of Information Officer receives the additional information. And another scenario. In addition to other information, a responsive record to a FOIA request contains a citizen's name, home address, and telephone number. The FOIA officer denies the request and withholds the entire record. Is this the correct decision? A, yes, to protect the citizen's personal privacy. B, no, it became public once turned over to the district. C, redact the personal information, then release. And D, redact the name and release. C. Number of folks have entered C into the chat, and that is the correct answer. And this is the redaction rule under DC Official Code 2-534B, which allows for the release of the records by concealing the exempt portions from public view. The justification for the deletion must be explained fully in writing, and the extent of the deletion must be indicated on the portion of the record which is made available or published, unless including that indication would harm an interest protected by an exemption under which the deletion is made. If technically feasible, the extent of the deletion and the specific exemptions shall be indicated at the place in the record where the deletion was made. Okay, a requester says, I want the information in an Excel spreadsheet. Okay, the agency does not keep the requested information in spreadsheet form. Then choose amongst the following options. A, FOIA officer should create a spreadsheet for the requester. B, supply records in the form the agency maintains. Or C, send records to a third-party vendor that can timely create the spreadsheet. Okay, and the correct response is B. FOIA does not require an agency to create documents or opinions in response to an individual's request for information or to obtain records from another agency, nor does an agency have to respond to questions disguised as a FOIA request. And then this comes from case law in Dugan v. DOJ. Okay. Gone up in smoke. On Thursday, a few records contained solely on the director's external hard drive were destroyed by a small office fire, causing the hard drive to explode. The next day, the FOIA officer receives a FOIA submission requesting copies of some of the destroyed documents. So in this scenario, should you A, ask the director if she is able to recreate the documents? B, wait until DC Fire and EMS complete their report regarding the cause of the fire? Fire and EMS says it will take 6 months to complete its report. Or C, immediately notify the requester that the documents were destroyed and no longer exist. And the correct answer is C. So remember, there is no obligation under DC FOIA to create records that don't exist. 407.3 states that if a requested record is known to have been destroyed or otherwise disposed of, the requester shall be notified. FOIA fees. A public body may establish and collect fees not to exceed the actual cost of searching for, reviewing, redacting, and making copies of records. Documents may be furnished without charge or at a reduced charge where a public body determines that waiver or reduction of the fee is in the public interest, because furnishing the information can be considered as primarily benefiting the general public. This comes from DC Official Code 2-532B. Section A, commercial search, duplication, and review. B, educational, non-commercial, scientific research, media, duplication, and then C, if not A or B, search and duplication. A requester seeking a waiver or reduction of fees shall provide a statement in his or her request letter explaining how the requested records will be used to benefit the general public. Advance payment is allowed when the request will exceed $250 or the requester has previously failed to pay. These are payable to the general fund. With regard to denials, denial by a public body must contain the specific reasons for the denial, including citations to the particular exemption or exemptions under Section 2-534 that were relied upon as an authority for the denial, the name or names of the public officials or employees responsible for the decision to deny the request, and notification to the requester of any administrative or judicial right to appeal under DC Official Code Section 2-537. Okay. A requester who receives a letter of denial or where an agency fails to supply the record within the statutory time frame may file an administrative appeal one of two ways, either with the mayor's office or they may institute proceedings in DC Superior Court. Within 5 days, excluding Saturdays, Sundays, or legal holidays of receipt of an administrative FOIA appeal, the agency must file a response. An agency may request additional time to file the response to the FOIA appeal by filing a written or emailed request with a copy to the requester within 5 days, excluding Saturdays, Sundays, or legal holidays of receipt of an administrative FOIA. Failure of an agency to respond to an administrative appeal during the 5-day period or an extension granted constitutes a waiver of its rights to respond to the appeal. Annual reporting requirements. On or before February 1st of each year, the mayor shall request from each public body and submit to the council a report covering the public record disclosure activities of each public body during the preceding fiscal year. The Corporation Council, now known as OAG, shall submit an annual report on or before February 1st of each calendar year, which shall include for the prior fiscal year a listing of the number of cases arising under this section, the exemption involved in each case, the disposition of the case, and the costs assessed pursuant to DC Official Code 2-538C. Okay. And that concludes the training. Here is contact information for myself and my colleagues. The Office of Open Government is led by Director Nikel Allen. Our Chief Counsel is Lewis Neal. I, again, am Brandon Lewis. And my colleagues are Anthony Scarborough, Attorney Advisor, Joan Lelma, Attorney Advisor, our paralegal specialist, Kimberly Brown, and our IT specialist, Kevin Brown. And here's all of our contact information. And I would be happy to take any questions that my colleagues may not have had a chance to get to in the chat. So we go to the chat and see if there's anything that hasn't been addressed. I see a question from Zachary Hill. Said, I have a question about fees. If a requester is anonymous, we don't know if they previously failed to pay fees or if they also don't say why they want records, whether we can charge fees for document review. In that scenario, should a FOIA officer ask the requester to identify themselves? With regard to knowing whether or not they had previously paid the fees, well, let me back up. So DC FOIA does allow people to make requests anonymously. And so I think if you were trying to only contact the requester for the purposes of seeing whether or not they had failed to pay fees before, I don't know that you would be able to do that. With regards to I think in parentheses, he said also don't say why they want the records. Unless they were seeking a fee waiver, I don't know that why they want the records would be material either. So again, DC FOIA permits someone to make an anonymous request as long as the request is reasonably described, then you should be able to respond to the request.
I'm so sorry. I'm sorry to come off mute. I think what I'm confused is, did I understand you correctly that, depending on why documents are being requested, you can either charge search and duplication fees or search, duplication, and document review fees?
So, sorry, and I think it might be helpful if I can go back to the part about fees, which I think is requested. Give me a moment to see if I can share my screen again. Okay, so with regard to fees, a public body can establish and collect fees that are associated with searching for, reviewing, redacting, and making copies of the records. So I think what you may have been asking about with regard to the purpose may have to do more so with a fee waiver. Okay, and so with respect to a fee waiver, a requester seeking a waiver or a reduction of fees has to provide a statement in the request letter explaining how the requested records will be used to benefit the general public. So for instance, if you got a request from a local news outlet, and they wanted you to waive the fees, they would, in that instance, be explaining how the requested records would be of benefit to the general public, presumably through their reporting of something that would benefit the public at large to know. But just an individual who doesn't fall under that category, like they're just requesting it for their own reasons, would not necessarily be entitled to a fee. A fee waiver. But anyone who was requesting the fee waiver would need to provide that statement that's explaining how their intended use of those records would benefit the public in general. Does that make sense?
Yeah, I'm sorry. Do you mind going back to the previous slide? I'm sorry to hijack this. So my question is, we recently received a FOIA request that required a large amount of redaction. And if I'm understanding this correctly, we can only charge fees for redaction if the records are for a commercial purpose. And that the request didn't come with a fee waiver, but we couldn't charge fees for redaction if it was not for a commercial purpose. But the person didn't say what purpose it's for. Just saying, here's a FOIA request, I'm asking for these records, and the request was anonymous, so there's no context about, oh, you're from a company. So in that scenario, I guess, what can we do to figure out what category of work we're even allowed to charge fees for?
And I'm sorry, I want to make sure I'm understanding your request or your question correctly. And also any of my colleagues who may have understood this, feel free to jump in. So you're saying that there were a number of redactions that you made, but the entity was anonymous, but they were not requesting a fee waiver. Is that correct?
Correct. But if we were charging for the redactions, it would have been a lot of money. And if we were not charging for the redactions, it would have more or less been free.
And you're saying because it was anonymous that you would not know who to give the charge to for the redactions?
We wouldn't know whether we could charge for the redactions, because if I'm reading this correctly, you can only charge for redactions if it falls into the commercial category, because redactions are document review. Whereas if it's not in the commercial category, you can only charge for searching and duplicating the documents.
Well, I think in this instance, the individual didn't request a fee waiver. I think, you would assess the cost of the redactions and then notify the requester of the cost that you have assessed for those redactions. And, I think if they're an entity who is falling under the fee waiver at that point, I think it would be appropriate for them to explain why they need a fee waiver. Otherwise, I think you should just, assess the charges for the redactions.
Got it. Thank you.
Okay. Just looking briefly in the chat to see if I've missed anything. I did see someone said, how do we respond to a requester who uses the name John Doe, I think you would respond normally, assuming that you have information on how to contact them and to deliver the requested records to them, and the request is reasonably describes what's being searched for. The fact that they have attached the name John Doe would not change anything else about the rest of how you would respond to that FOIA request. My colleague answered this in the chat, but just to make sure everyone is aware, we will make this PowerPoint available to you. I'm not seeing any other questions in the chat, but also if you have any additional questions now, feel free to either type them in the chat or take yourself off mute and ask. Okay. And I see, excuse me, I see a question from Allison Hughes with regards to, is it okay to charge the reviewers hourly salary? That one, I actually, that is a good question. I'm going to have to get back to you on that.
Okay, thank you.
I can help. This is Nicole Allen. So the fee schedule and how much you charge is in the DCMR. We'll make sure that you have a copy of that, but there's a actual, it tells you how much you can charge per employee, by grade, et cetera. So I would say to find out how much you can charge, look at the DCMR.
Okay, thank you, Miss Allen. I thought so. I wasn't clear when I saw that we could establish the fee. I knew that we weren't allowed in the past to charge the entire
Yeah, I guess
hourly.
established, that can be established by regulation, so the executive can establish a
Yes,
charge
okay.
fee. But for now, that's what it is. It's what's in the DCMR.
Okay, thank you.
Thank you for the question.
And thank you, Director Allen, for that response.
You're welcome.
Okay, and there was a question about when the next training will be, and you can see it there in the chat, scheduled for May 20th, 2025, also at 2 p.m.
And this is Director Allen again. If you all have some training topics that you're interested in, or some things that you would just like to hear from us about, please send any of us an email, and let us know so it can help us to tailor our training topics for the future. And we'll also have our training series again that's going to happen this summer that's on various FOIA topics. So that would help us if you all have specific things that you would like to have a more in-depth training on. Please reach out to us and let us know. No, thanks, Brandon. I'll hand it back to you.
Okay. And if there are no further questions, we'll go ahead and end, but I will stick around for the next couple of minutes just in case any questions come to mind. But if not, thank you for joining us today. And we hope that you will join us for one of our future trainings. And If you know anyone in DC government, any FOIA officers who would benefit, also please let them know to attend our next training. Thank you.